Yeah. Thank you very much, dear Richards, and welcome to Riga. And I hope I haven't forgotten the English and talk English about copyright. And before we proceed with the presentations, I would like to remind of the time frame. And it is about 25 minutes for each speaker. And then we will leave some 5 minutes probably for a couple of questions. But if we don't have time, then we will have 2 hours afterwards, after the copy break, which will start at 3:45. As regards the participation of the audience, then you will be able to ask your questions straight from your seat. And the other option is to write your questions on email, which is mentioned here. Now, I would like to invite Professor Silke von Lewinski to start the first presentation. Silke is tenured at the Max Planck Institute for Innovation and Competition in Munich and specializes in international and European copyright law. She's also adjunct professor at Franklin Pierce Center for IP at the University of New Hampshire Law School in Concord in the USA. And she's also a docent in the University of Zagreb. I would also like to mention that Professor von Lewinski has also contributed to the content of the Latvian copyright law, as she has been the chief legal expert consulting the governments of Eastern and Central European countries on their copyright legislation in the framework of the European Community Technical Assistance Programs. So thank you also for that. And you can find more extended information about the accomplishments of Silke, von Lewinski, and other speakers in the material distributed, the reader. So, the title of presentation is going to be, well, it's a bit different here. No. So, it's about copyright exceptions again. And, yeah. Well, but it's going to be probably more about the current framework, not the ways forward, right? Okay, so thank you very much, and the floor is yours.
Thank you very much, Ilona, and thank you very much also to the Latvian presidency for having me invited here. Special thanks to Richard. It's a pleasure actually to come back after all these many years when I first came quite early, I think in the 1990s, to talk to the government on how to adapt the Latvian law to the European acquis communautaire. As Ilona said, I will, since I'm the first speaker of the academic panel, this doesn't work, or could it be? Do you have another one? Or at least it doesn't work when I press. Okay, so will you do? So I indicate? Okay, fine. Since I'm the first speaker of the academic panel, I thought I would set briefly the scene and so that we can see what is there and what, in the light of what is being discussed, of course, because Richard told me also we could have some conclusions towards what should be done against the background of what we have. So just to recall that, of course, we have exceptions and limitations in different directives, including the Computer Programs and Database Directive and newly the Orphan Works Directive. And I will only talk about the Information Society Directive. To go back to the historical background, which is sometimes forgotten, as Maria also said already, the national law in respect of exceptions and limitations is quite diverse, has always been very diverse, and that is actually one reason why also on the international level we do not have any particular specific harmonization of exceptions and limitations. And even in the 2001 directive, it was not possible, and member states did not want to go further than what we have today. For example, in the Anglo-Saxon legal system, we have certain fair dealing exceptions which allow for a certain flexibility, but only in very clearly determined cases. In addition, the UK also has detailed exceptions and limitations which are quite, which have a high level of detail. At the same time, we do not find, at least at the time, we did not find any remuneration rights connected to exceptions and limitations. And you know all about the current or the problem, so to say, to have a remuneration right for private copying in the UK. So that's not really in the spirit of the system in the Anglo-Saxon world. In contrast, in the continental European system, we only have specific detailed exceptions and limitations, but even there we find quite broad differences between different continental European countries. For example, if you compare France and Germany's laws, in France usually the exceptions are fewer and also less detailed. In Germany we have a long list of quite detailed exceptions and limitations. And secondly, even within the family of the continental European countries, we do have differences as regards the connected remuneration rights. Many have, or even due to the directive, most have remuneration rights for private copying and some others, but for example, again, the German law has a huge list of remuneration rights connected to exceptions and limitations. So that's another main difference. Against this national law background, of course, Article 5 of the Information Society Directive was adopted. First, as you may recall, it was planned only to have selected a few facultative exceptions and limitations. And when during the legislative process it became then clear that there should be a closed list of exceptions and limitations, which means that no other limitations would be permitted than those explicitly written in the directive, then of course it was clear that many member states came up, checked their national laws and said, well, we have another limitation here which we want to keep, so in order to be able to keep that, we have to include it into the list. But this did by no means mean that they wanted all the other member states to adopt the same limitations. So there was no aim of full harmonization from the beginning on. And that is actually also reflected in recital 31, which says this directive does not want full harmonization. So those who sometimes say, well, this is a failure because we don't have harmonization here, it's not correct. It was a deliberate choice because of this diversity to harmonize only the outer limits. So it's a partial harmonization. There is some harmonization, but it is limited to the outer framework, saying to member states, you can go so far, you can stretch the exceptions and limitations so far, but not further. That's the harmonizing part of it. Of course, this means that member states have the choice for the different exceptions and limitations, either not to introduce a particular exception or limitation, or to do so, and either to be more restrictive than permitted, which means to grant stronger protection, or to make full use of the outer framework, which is permitted by Article 5 of the Information Society Directive. So again, to recall what you all know, there's only one mandatory exception and limitation in Article 5.1 for the temporary reproduction. All the others are facultative, again, against the historical background I just mentioned. But if they are applied in national law, they must respect these outer limits set out in the directive. Article 5.2 regards only exceptions to the reproduction right, Article 5.3 those to reproduction and communication rights, and Article 5.4 to the distribution right, and then we have 5.5 with the three-step test, which comes in addition to the conditions already explicitly mentioned in the specific provisions before that. So which means that there is actually flexibility for member states. That's what Maria was referring to, at which level we should have flexibility. There is flexibility for member states within this mandatory outer framework. Now, let's see what the court made out of that. Speaking in general terms, not only for exceptions and limitations, we have seen that the court uses different methods of interpretation and sometimes chooses the one or another time the other one. What you find usually is the wording, the systematic context, the teleologic interpretation, so what is the object of the provision or the directive. What is very often the case also is the autonomous interpretation and uniform interpretation of terms used in the directives, unless the directive says this is not to be considered a harmonized term but left to national law interpretation. And that's actually a point which maybe was not, or of which member states maybe were not aware when they legislated. I remember I was myself giving advice, or the legal expert of the Commission for the EC Rental Directive at the time, and I remember the discussions, and it was underlying that member states thought, well, we have some flexibility in interpreting the term public or whatever, which has been proven true when one of the cases was it on communication to the public, I think, where Austria made a submission to the court saying, in our view, this is not to be considered as a harmonized term. We thought we would be flexible in interpreting this or that term. So this may have to be taken into account in future lawmaking. The other methods of interpretation sometimes used is that principles should be interpreted broadly and exceptions narrowly. Then you have effet utile. Sometimes the court refers to principles established in other intellectual property directives, which it thinks is a principle, which is kind of dangerous, because if you have some particular provisions which were meant to be decide or valid only for a particular even kind of work, such as computer programs, and if the court would then establish on this basis a principle which was meant to be an exception or a very specific regulation, we are in trouble. So for the lawmaker, it's always very important to make your understanding clear of what you legislate. Otherwise, you have, of course, the underlying fundamental rights and underlying international law, which is binding the EU. So on this basis of all these varied methods, it is not always easy to predict what the court will decide in a given case. All the more since sometimes we have seen the court has been quite audacious, or arguably even cutting into the competence of the legislature. I'm referring here to the, in particular, the Infopact decision on the term of work, which is not subject of today, but as a matter of principle, we have to be aware that the court might be very proactive, so to say. Then we have to see also that sometimes national courts, or academics anyway, would have a possibility to interpret decisions by the Court of Justice in different ways, because what the Court of Justice says is not always crystal clear and subject to interpretation again. So there is again something left as a legal uncertainty. And sometimes maybe the legislator has to step in to clarify things as they were meant. One may also, for example, understand Article 5 of the Information Society Directive as only applying to cases where the internal market is at stake, because that's where the competence is. So sometimes one might interpret narrowly a court case, saying, well, this is anyway only valid for transporter situations. And I think when interpreting court cases, one should also take into account that the concept of Article 5, as I explained it, namely that it only harmonizes the outer limits of what is permitted for providing exceptions and limitations. One example is the Denmark Radio versus NCB case, where on ephemeral recordings, where the court stated that the broadcaster's own facilities, also according to recital 41, include those used by a third party on behalf of the broadcaster. But one has to understand that as the outer limit. So if a national law provides a limitation which would be more restrictive and saying, well, I don't include the third party's facilities, I think it would still be allowed under the directive. Same for the parody case, where it said that parody means this and this, and the notion is not subject to certain conditions. One can also interpret this case as saying, and should, I think, these are only the outer limits. If a national legislation wants to be more restrictive and say, well, we still provide, in addition, these and these conditions for the exception to apply and thereby make it narrow, it should be allowed, because they could also say we don't provide for any exception or limitation. So I think that's a matter of logics. Sometimes that's a different point. Court cases are not necessarily or arguably not in compliance with the underlying international law. I'm referring here to the notion of communication to the public. Although it is a right, I have to say the court has carved out certain elements of this right, which should, if at all, should be covered by the system of exceptions and limitations. Namely, in particular, by requiring as a condition for the communication to the public to apply the criterion of a new public and of a for-profit communication. These are criteria or conditions which are limiting the application, the scope of application of the communication right, and which are not contained in any way in the international treaties which are binding the European Union, and therefore are narrower as the minimum which must be provided. That's actually also the opinion of the Alain Executive Committee, which has published an opinion on that. So I think one could argue the court violates the underlying international law by these criteria. A similar case could be made for the distribution right in the Ustov case, where the court simply carved out, I would say, from the communication right, what it calls the exhaustion of distribution, where the distribution right in the first place should not have applied, and the communication right does not provide for an exhaustion as carved out. So these are things to look at also maybe in any future lawmaking. Oops, yes. So to conclude on the case law, with a view to legislation, where certain issues or definitions are to be reserved for determination by member states, I think in the future national EU law should state so explicitly and be more aware of the otherwise applied autonomous interpretation by the court. And as I just said, if the court's case law is likely to contravene underlying international law, I think it should be up to the legislature to correct, so to say, this situation and clarify what is in fact covered by the communication or distribution right. And in general, the more precise the EU legislation defines terms and rules, the better it should be, I think, the more predictable it will be. If you look at how the court has practiced the interpretation of copyright directives. And we all know there are no copyright experts there, so we cannot expect from them to be to judge like expert judges. In this context, one should also see that if there is too much flexibility left to judges we would certainly have a tsunami of cases, not only under national law, but also then going up to the European Court, if this were stipulated in European law, if a flexible clause instead of more precise terms would be set out in European law. And this means normally very, very long proceedings. We have had this with private copying in Germany, I think for, 8 years or several years overall, going through all the instances, then going to the European Court, going back, going to the Constitutional Court, going back, etc. So you can have a really long legal proceedings, and if you see that what is treated in preliminary rulings by the court is, of course, only answers to very precise questions, I think that's not a good solution. You will have hundreds of cases because the life is so full of different situations and different questions that I think it is much better for the legislator to determine in quite concrete terms what it thinks is necessary to determine. So with too much flexibility, we have a long period with legal uncertainty. And in addition, there's a negative impact on remuneration rights, because if you don't know whether an exception applies and therefore the remuneration right applies, you will not be able to claim that remuneration for the long time until it is clarified that the exception actually applies. Okay, now coming to why we are here, more or less. As Maria has already said, there are many claims to make a review of or reform of current copyright, and what is mainly talked about and mainly brought forward by internet service providers and other users is to have an overall review of the Information Society Directive, and in particular to make exceptions and limitations mandatory and to reach more harmonization. I assume that this is wanted only if the exceptions and limitations are sufficiently broad so that they are fine, but otherwise not necessarily. This goes also for the claim to have a single unitary title. As Mr. Lüders, the predecessor of Maria, also already said some years ago at the Fordham conference, his observation was that those who want to have a single unitary title would no longer want that if there would be a solid protection rather than broad exceptions and limitations. So it is not really the aim of having a single unitary title, but to nail down broad exceptions and limitations, which is behind this claim. They claim also, of course, more flexible clauses for exceptions and limitations. Sometimes they say there should only be the three-step test. And just as a matter of memory, this was already claimed by some in the legislative procedure towards the Information Society Directive, and was rejected at the time, meaning to have only the three-step test as the only limitation which is permitted without any specific indications. Of course, when I say here importation of the fair use idea, we all know where this comes from. Google has made it clear at the Fordham conference again that they were satisfied that fair use is spreading over the world, and that they don't insist that covenants or that legislations would take on board the American fair use concept, but they would already be happy if they would take on some form of flexibility. So I think without Google we would not discuss fair use or flexibilities in Europe. But we are there, we have to discuss it. Then the question of carve-outs from exclusive rights, which I mentioned earlier. That's also, of course, it was already a claim of internet service providers at the WIPO Diplomatic Conference 1996 to carve out from the making available right in particular and the reproduction right certain uses on the internet. They wanted to be totally free to not to be hampered by copyright. And then we decided, no, there should be a principle of a broad right, and the concerns of the ISPs should be dealt with in the framework of liability rules. which was the way taken. So we have to see that this discussion should not come back, and that we rather talk about liability rules. At the same time, I think there's also time to, if we talk about exceptions and limitations, to talk about a better involvement or better responsibilities of ISPs who are quite much benefiting from the current situation. Now, in response to such claims, let me just say some words. As a legislator, I think it is necessary anyway to ascertain that there is an obstacle to the free movement. That's the basis, we know it. It's the competence of the EU is limited to such cases to remedy obstacles to the free movement, which is maybe not always the case. As Maria said also, we have so many purely local uses, especially in the field of education. Look at schools. Latvian school books, who would want to have them in Germany or in any other member states? Not because they would be bad, but because of language and of culture and of public law curricula. That's what we have also. There are certain contents which must be taught to the pupils, and these are different in different member states. So there are many other external facts for saying that there's no need for for cross-border exchange of such material. So we have to look in each individual case: is there really an obstacle to free trade, to free movement, and is it there not only in some individual isolated cases, but in a major economic way? So that's what I mean by we have to measure also the impact on the internal market, whether it's just some isolated examples of someone who is living in a foreign country and needs some work or whatever. Then, of course, the need to respect principles of proportionality and subsidiarity. Mr. Juncker has stated so explicitly in his letter to Mr. Oettinger. And the need to respect cultural diversity is also an obligation, and this plays a role especially in fields such as education or culture-related institutions, where we have, in fact, quite a big diversity in the member states. Now, on the issue of the claim to have flexible clauses within European law, again, I think this would result in less legal certainty, and, by the way, also in problems in respect of criminal law, because whether or not there's an infringement or a free use has impacts on criminal law, which must be precise. Then, as I mentioned, there would be problems for the related remuneration rights. There would be long reactions to technical changes, because until we really know what a flexible clause means in an individual case, we have to wait for years, and it may be faster and preciser and more harmonizing, so to say, if we have legislative acts here where necessary. I also think the judicial system of the continent is not really well equipped to having these broad clauses, and we have, at least on the continent, this art of drafting legislation which is abstract enough to cover many cases, to incorporate certain values and to be future-oriented, instead of having just tiny little advocate-made laws. So I think we have this tradition of drafting legislation which is future-proof, and of course, if there are more technical developments coming up which don't fall under that, I think it is fair to say legislation is a good way, possibly even better than to broad clauses which will lead to a jungle of particular detailed provisions on the basis of case law. One should also look into the division of powers. For example, the German Constitution on the fundamental right of property in Article 14 says that properties, it has been interpreted that IP is protected by property, and that the limitations and exceptions must be drawn by the legislator. So it's up to the legislator, not to the judge, to have these broad determinations. And one should also see that in such a system of too flexible limitations and exceptions, it will always be the big users who will win before the courts because they have the most money for the best attorneys, etc. And even the small users will not benefit, maybe not at all or not in the same way of this flexibility. So it actually favors the big, which are already, which don't need that actually. I'm coming closer to the end. On the issue of competence, even if we can find that there is an obstacle to free movement, it does not automatically mean that one needs an exception or limitation. This is sometimes also in the discussion mixed up. It's one possible answer. There are other options such as individual or even collective licensing, maybe even mandatory collective licensing. Just to mention, in the rental right directive, this was made. The exclusive rental right was actually introduced, although they knew that that would not be licensed afterwards, in order to have the same situation in all the member states. So even the option of not exercising it, theoretically, I don't recommend that here, but would be an option to get away with trade barriers, is this reaction to the Warner Brothers case at the time. One could also think of, if one harmonizes further limitations and exceptions, that one only separates or harmonizes the part of a certain situation which is cross-border related. So, for example, cross-border education instead of local education, etc., or library uses locally, which are member states' competence, in opposition to, or in contrast to, cross-border library uses. Then one should also take into account that not any reason is a justification for an exception and limitation. So to say, for example, well, people like to do that and it's fun and so on, like for user-generated content, I'm not sure whether that's a sound policy reason to have an exception or limitation. Also, the arguments to have new business models or innovation as such, I think, is not a value as such. It always depends on what the business model does and what the values are and what the balance between the different interests protected by law are. The argument of we don't have a possibility to enforce exclusive rights, well, might be also challenged by trying to enforce them better, to have better rules to enforce them. Okay, and there should be particular policy reasons. I should come to the end. My conclusion is, of course, the big vision, which some politicians sometimes have, is certainly not appropriate and not goal-oriented for European harmonization of authors' rights. One thought is also try to not give too much food for the European Court, which is not a copyright experts' court, but rather focus on legislative measures where necessary. And then in the field of exceptions and limitations, make a thorough analysis of the markets, of the internal market problematic, of only address those internal market problems and take into account the principles I mentioned earlier and avoid destroying some well-working systems which we have. This would mean a lot of transaction costs and no progress. Thank you very much.
Thank you so much, Silke, for this brilliant overview and also a look into the challenges of the future. We are out of the time, but maybe we can have one question. Is there anybody who would like to ask something? Or not now? Okay, we can leave. Oh, there is one question. Very nice. The brave person first.
Many thanks. My name is Dietmar Dokalik from Austria. Silke, I broadly agree with almost everything you said. And I also took note of your advice that we shouldn't give the European Court of Justice too much food. But I think the lawmaking, I think in a perfect world you would be right, taking into account our constitutions. But the lawmaker that has to face elections is not too unhappy to shift the powers to the European Court of Justice. And from the Austrian perspective, the European Court of Justice and our national courts have been a motor in evolving the concepts of copyright, and not always to the worst of copyright. For example, it has nothing to do with exceptions, limitations, but at the UPC Telekabel case of the pirate site Kino.to, if the Austrian lawmaker would have involved such a concept of website blocking, it would have been censorship to the public. But if the European Court of Justice says so, everybody can accept it. And I think the lawmakers often are not too unhappy that the European Court of Justice has to do the things he has to do. Just a remark.
Thank you so much. Would you like to comment a bit?
Yes, it's true, and I don't want to give the impression that I'm only talking in bad terms of the European Court. I agree that there have been very many good and logical and intelligible solutions and decisions by the court. It's not everything. I only pointed out the critical ones. Yeah.
Thank you so much. So now I would like to invite Professor Martin Senftleben. He is the professor of intellectual property and director of the Kooijmans Institute for Law and Governance at the Free University of Amsterdam and of counsel at Bird and Bird in The Hague. And he is going to talk about the tragedy of three-step test. So welcome.
Thank you so much. Thank you so much for inviting me over. Well, nomen est omen, so when you read the title, you can already imagine that there might be some disagreement in the academic community, at least, concerning the issue of flexibility and open-ended clauses within the system of exceptions and limitations. I'm referring to the three-step test tragedy, and I explain you in a second what I mean by making this reference, but let's first have a look at the current EU legal framework for exceptions and limitations. As we all know, there is a broad, generous grant of exclusive rights, right of reproduction, right of communication to the public, right of distribution. Then we have, as Silke already brilliantly explained, we have this exhaustive enumeration of exceptions and limitations in Article 5. But this is not the end of the story. We do not only have these specific exceptions and limitations, quite a long list. On top of that, we have the three-step test. So practically speaking, this means that a use, in order to be permissible in the EU framework, first of all has to fit into the framework that is established in Article 5, and then on top of that, it has to comply with the three-step test. This is the three-step test, and you can see how much legal certainty you find in the test itself. So if you can tell me what a certain special case is, what normal exploitation is, and what unreasonable prejudice is, and what legitimate interest is, then let's discuss this later on during coffee. So this is how far we get in terms of legal certainty in the European Union. Yeah? So this is what proponents of legal certainty sell to you as a source of legal certainty in the European Union. I have spent about 3 years of my life writing about this provision, which was my doctoral thesis, and I can tell you I made some suggestions, but still we do not know, and I really did my best. What does the Court of Justice say? Well, the Court of Justice quite traditionally says, okay, on the one hand we have general principles in EU law, so this is the protection of copyright, and we have these subversive exceptions that have to be interpreted narrowly and to be applied narrowly. And the court says, well, this is all the more so given that the exemption must be interpreted in the light of Article 5.5, which is the three-step test. And this brings me to the point of a tragedy. This is a worst-case scenario. Could not be worse. It could not be more dysfunctional if you think about it for a second. And thinking about it means we make a comparison. We have two legal traditions. On the one hand, the Anglo-American tradition, Silke already referred to it, where you have a list of specific exceptions and limitations, and on top of that, you have an open-ended fair use provision. The US example is a prominent example, but we see more and more countries adhering to that model. So Singapore has done so, Israel has done so. So there is a move afoot, including these fair use provisions. So this system has the advantage of flexibility. And we have the continental European system, which I say is the system that you had traditionally in the member states. So traditionally in the member states at the national level, you had this system. You had these precisely defined exceptions. And I must admit, and this is true, the advantage here is, in fact, legal certainty. This offers more legal certainty than the fair use system. Hardly any doubt about it. In particular, when you think about the legal certainty in the books. I mean, in a fair use system, when you have a long tradition of case law, hundreds of years, like in the US, then you have legal certainty because of the robust body of case law, yes. So these are the two systems, and these are the two advantages, flexibility and legal certainty. And now look at the present EU framework, and you will see we have the closed catalog controlled by open factors. So you have no flexibility, and you have no legal certainty. Because the flexibility you could have because of the three-step test is not there, because the three-step test cannot be used to open up the system. And you can't have legal certainty because a user in your countries who wants to rely on one of the specific exceptions which you have drafted carefully in your ministries will never know what the judges finally make of it because of the three-step test, because of this test of certain special case, normal exploitation, legitimate interest, and so on. So you have neither the one nor the other, and this is something we afford us in the EU system where legislative processes are not only slow. I mean, with all due respect, and I think even Maria gets tired of the lengthiness of the process, you need minimum 10 years to come up with a new legislation. So when you start the process now, I mean, the old copyright directive is from 2001, so we are already 10 years further. So you start discussing this now. So the reactions are very slow, and they are definitely slower than they are at the national level. Well, we see this problem of not the one advantage, not the other advantage at the national level. Doesn't matter whether the three-step test is in the law or not. In France it is in the law, in the Netherlands it's not in the law, but the three-step test comes on top of the specific exceptions and limitations. So the advantage of a system like France is that the users at least know when reading the legislative test that the three-step test is a factor of legal uncertainty coming on top of that. So what could you do about it? Well, you could do either one or the other. You could say, okay, we don't use the three-step test any longer. We only fix exceptions and limitations, make them mandatory, full stop. Or you could do the other thing. You could open up the system and you could opt for more flexibility. And I'm not saying revolutionizing the system. I'm only saying fine-tuning the system, recalibrating the system. So what could you do? You could keep the list that you have, all these exceptions and limitations that are long-standing, that we love, that reflect cultural traditions and so on. Keep the list as it is and add as a final point an opening clause saying that in cases that are comparable with something on the list, the judges can design a new type of exception and limitation considering the three-step test. In that way, you open up the system and it will not become very outrageous anyway because the conditions of the three-step test, as we all know, are normal exploitation, no unreasonable prejudice, and so on. So it is a very rights owner-friendly test anyway. So this is what you could do. The counter-argument that I always hear is civil law judges can't do that. They don't know how to deal with open-ended exceptions and limitations because there is no other area of law where a civil law judge could at some point be confronted with an open-ended provision. Well, I don't know about your legal traditions, but as far as I know, private law, civil law is full of open-ended provisions. So I come originally from Germany, Treu und Glauben is one of those open-ended provisions, and when I can believe the historical analysis of German law, then it is in particular because of this open-ended provision that the Federal Court of Justice in Germany managed to adapt a legislation, the Bürgerliche Gesetzbuch, which was already outdated at the time it was introduced because it reflected a society that was no longer present. It reflected the old Bismarck society, which was moving on to an industrialized society. So it was outdated when the code entered into force. How did the court manage to adapt the code to new developments? Well, because of this opening clause, because of a clause saying, well, Treu und Glauben, in Dutch it's Redlichkeit and Billigkeit, and I would really be surprised if in your countries you do not have some standard of general reasonableness, justifiedness, and so on in your countries. Okay, so are civil law judges capable of dealing with such an open-ended clause? Yes, they are, I can tell you. So there are lots and lots of examples for this, so they are absolutely able of doing so. And by the way, why being so restrictive? There seems to be a belief in the European Union that the three-step test by definition means that you have to be restrictive. Recital 44 of the InfoSoc Directive, or the Copyright Directive, says when applying exceptions and limitations provided for in this directive, they should be exercised in accordance with international obligations. And then a reference to the three-step test. So what are these international obligations? Are we prevented from being a bit more flexible because of international law? Well, the international obligation is quite a flexible acquis. The three-step test was, let's say, a magical formula for agreeing on new international standards in almost all major treaties in the area of copyright that we have nowadays. It started with 9.2 of the Berne Convention, then 13 TRIPS, then 10 of the WIPO Copyright Treaty. I could add the more recent treaties like the Beijing Treaty and the Marrakesh Treaty, but I stop at the level of the WIPO Copyright Treaty because Article 10 of the WIPO Copyright Treaty is accompanied by quite an interesting agreed statement. It says, with regard to the digital environment, it is understood that the provisions of Article 10 permit contracting parties to carry forward and appropriately extend into the digital environment limitations and exceptions in their national laws which have been considered acceptable under the Berne Convention. So you can update what you already had under the Berne Convention and you can bring it to a higher level, to a new level of application in the digital environment. But on top of that, similarly, these provisions, and that's a reference to the three-step test, should be understood to permit contracting parties to devise new exceptions and limitations that are appropriate in the digital network environment. So the three-step test internationally is an invitation to update copyright to the digital environment. And why is this so important? Well, if you don't do a good job here, you lose copyright altogether. I don't know about your countries, but people on the street hardly believe in copyright any longer. The social legitimacy of copyright is already at stake, or it is perhaps even lost in some cases. And I'm not the only person saying this. When we had the 100th anniversary celebrations of the Dutch Copyright Act, it was Francis Scurry, the Director General of the WIPO, that came over and said, you have to take care that copyright does not lose its social legitimacy. So this is the invitation to do it. And the invitation is to do it on the basis of the three-step test. So don't be sitting here and thinking, okay, we are doing fine. You are not. You are losing the whole area of law altogether. So impact on the EU single market. Well, first of all, the traditional copyright-centric view will not help us any further here. You must understand that the world has become more complex for copyright policymakers with the digital environment. And where can you see this? In the Charter of Fundamental Rights. It's not only the copyright holder with property rights, it's also consumers with privacy concerns, with freedom of expression, freedom of information concerns. It's content aggregators. They are businesses and they have a freedom to conduct a business. So we have to open up the system to understand this broader reality. It's no longer a one-dimensional thing. It's at least three-dimensional, or it has even more dimension. And you have to balance this. If you don't do an appropriate balancing, well, then you leave, then you have insufficient room for new business models and information services. and you have less freedom of expression and information. And here you're saying, okay, well, this is just the general, these are the general things that are always brought forward in the debate. So here come practical examples. The first one is a bad Google example. Yeah? Actually, many people think badly about the company, but we all love the services. So this is a search result of the Google image search. And I tell you, if in your country Google image search is no longer available today, then you will have difficult things to explain tomorrow. Yeah? So there are services that are very important as information services. And I tell you what has happened on the basis of the existing legal frameworks, which offers wonderfully legal certainty. The following happened. We had no productive system competition because the judges in copyright law did not have a common language to speak. But judges in various member states understood that this is a very important information service. So what did they do? The Dutch said, well, the Google image search, it falls under the right of quotation. So they kept it under copyright because the Dutch Copyright Act allows for quotations for the purpose of an announcement. So the judges said the Google image search is an announcement of the contents of the underlying web page. In Germany, they were a bit more dogmatic. Well, we are not surprised by that. They said, no. Right of quotation, this is something that only works when you make a comment, something critical about what you quote. So the German court developed a theory of implied consent. As far as I know, all commentators agree that this is complete legal fiction. Nobody really understands what it is, but they wanted to save this information service. In France, a country not necessarily known for being very liberal in copyright areas, in France they invented a safe harbor analogy to save this information service. And in Spain there is a case where they simply said, well, bringing such a claim against Google is outrageous and abuse of rights. This is the framework we have. This is what happened on the basis of this wonderful legal certainty framework that we have at the moment. And now I tell you another thing. What are the chances of the Court of Justice to do something about it? The chances are almost zero. Because most of these doctrines are not harmonized, so the court has no saying about it. And if the court says something about one solution, we still don't know about the other solutions. So the court has no chance of looking at the different developments in different member states, looking at this system competition, and then deciding for the most sensible solution the moment the question is put before him. This is why I think that an opening clause in copyright is much better. If you have an opening clause, all these 4 courts in 4 member states could have tried to solve the case on the basis of the three-step test. Solving the case on the basis of the three-step test does not mean that everything is permitted. It means that the courts look at it, that the courts make an assessment. Is it against a normal exploitation? Is it causing an unreasonable prejudice? And if the courts think it does not, they will explain why. So the Court of Justice would have had as source material 4 different interpretations from 4 different member states. And the moment the Court of Justice decides on it, it can say, okay, well, I think the interpretation applied in France is right, because the French are always right. So the interpretation applied in France is right. Yeah?
Not there. Exceptionally not there.
Not there. Okay. Anyway, but then I mean, you see, I just don't buy this this threat to harmonization purposes. The only thing is that we are too lazy. We want to see this system competition. We want to see this system competition going on in the member states, and then the Court of Justice can also do something that is more meaningful than just operating in a straitjacket of clearly fixed and defined cases. And I add another point. I can tell you also about the industry. I can tell you which type of industry loves this scenario. It's the big 4. The Googles, Facebooks, Twitters, and so on, Apples, Microsofts, they love this. Why? They have lawyers in all your countries anyway, and they have the deep pockets to afford all this legal arguments and all these court decisions. Doesn't matter to them. The more fragmented, the better. And I tell you who hates it, it's the small and medium-sized enterprises in your countries. Because they cannot afford this. And what do? Well, I know this from my own practice. From time to time, I have the privilege of advising some newcomers on new services. Most of the time, after they have sat with me for 3 or 4 hours thinking about legal solutions, they say, okay, let's go and sell it to Google. Because the legal risk is just too big. So if you keep this scenario, you just have more market concentration. That will be the result, and that's not only the example of search engine services. You will see the same with the whole big data, text and data mining debate, and who knows what comes next in the cloud environment. So I really think we need a change here. So don't believe the old stories about legal certainty and the European approach being fine. It is not. It is a worst case scenario, and you should change it as soon as possible. Thank you.
Thank you so much for this impressive analysis of the three-step test. So, would anybody like to ask something the professor?
Hi, so sorry if I'm the only one who's ignorant, but not knowing German or Dutch, this principle about the opening clause, how would you describe it in, say, English or French? In the German principle you were referring to?
Yeah, well, in German, I was referring to Treu und Glauben. In Dutch, it's Redelijkheid and Billigkeit. And in English, God helps me, it's reasonableness and proportionality, something like this. And in French, Valérie, would you have... Oh my God, I said it exists in all member states.
Voilà, c'est ça. Ne porte pas atteinte, alors, dans certains cas, ne porte pas atteinte à l'exploitation normale, ni ne cause un préjudice injustifié aux intérêts légitimes de l'auteur. Ah, ça, pardon. Ça, c'est la rédaction du droit civil. Et c'était quoi la question, pardon?
La question, c'était s'il y a un principe comparable à Treu und Glauben ou Redlichkeit und Billigkeit en France.
La bonne foi, la bonne foi.
La bonne foi.
Ouais.
Donc voilà, c'est ça.
Loyauté, bonne foi.
Thank you so much. Thank you so much for this presentation. Let's leave other questions for the discussion part. And let's welcome now Jonathan Griffiths, who is a reader in intellectual property law at Queen Mary, University of London. He has published widely on copyright law, particularly exceptions and limitations, and on the relationship between intellectual property and fundamental rights. So, the title of this his presentation will be "The Role of the Court of Justice in Interpreting Exceptions and Limitations." So, you have your floor. Thank you.
Thank you very much, and thank you very much for inviting me to Riga to do this. It's a great honour and a pleasure. Although this is a difficult slot, isn't it? Having heard two strong arguments of that nature, I'm now supposed to, I guess, be the referee. Well, I guess you'll be pleased to hear that that's not my intention. I'm going to shift focus a little bit at this moment and to look at something perhaps rather narrower, rather more academically focused on a piece of work that I'm doing at the moment. In particular, looking at the judicial methodology that the Court of Justice has employed recently in interpreting the exceptions and limitations. So, with some close links into what Silke said in the first presentation. Because whilst that's very strongly focusing on the now, seeing how the Court of Justice has been coming to its quite radical interpretations, I think it's possible to draw some limited but nevertheless interesting lessons from what we've seen the court doing for the project, the legislative project, that is now underway. Well, there's nobody in this room by this point, probably before you even came in through the door, who are not aware of the potential difficulties that commentary has identified within Article 5 of the Information Society Directive. We have the fact that we have a list of options. Many of the provisions within that list, of course, don't function as properly working exceptions and limitations in their own right. They are what commentators have described as categorically worded prototypes. That is, they describe a field rather than functioning as legal instruments. As a result, we've heard this particularly from Silke, we have a wide diversity of legal practice within the Union. Also, responses to the Commission's consultation on copyright reveal that there are other potential difficulties with Article 5 as well. So, in terms of the relationship with contract law, the extent to which these exceptions and limitations are mandatory or not. And finally, the big issue that our two previous speakers have really discussed most strongly, that's the tendency of the list to redundancy. So that is the potential that the list has for going out of date. The absence of apparent flexibility. Okay, so when the directive was passed over 10 years ago now, there was a flurry of commentary pointing out these difficulties. But what we've seen since then, and I think this is an absolutely fascinating process, is the court looking at that list and not simply accepting its limitations, actually seeking to solve the problems that we've identified there. And I think it's been mentioned that this is a non-specialist court. That's absolutely true. But I'm not sure these solutions have been arrived at by accident. I think there's more kind of thought in this than might necessarily have been thought originally. I think there's been an active intention to convert a problematic loose list of options into something that approaches a code of exceptions and limitations. And it's that process that I want to talk about. I both want to welcome it in some respects, to point out certain problems with how that process has arisen. So let's look at some of the solutions that we can find in the case law. So it's already been mentioned, this notion of an autonomous interpretation of the provisions. That's the court kind of grabbing authority to determine what the law is in this area. And Silke was very strong about this previously, clearly pointing to the fact that this was an interpretation of the upper limits, that is, the point beyond which member states must not go. And I guess all of us expected the Court of Justice to be involved in interpreting the directive in that way from its very beginning. That's its expected work. But I think the Court's done more than that. It's begun to organise its jurisprudence around a series of metaphors. So we see repeated references to the fact that harm needs to be taken into account. We saw that in Padoan, but we've seen it more recently in the DR and TV2 case from Denmark. We've seen the concept of narrow interpretation, which the court adopted in a sense as a way of steering through this diverse system. And then even more recently, we see very frequent references to this idea of a fair balance as the sort of, almost as a compass to guide in the process of creating law out of this list. But I think the court has been even more active than that recently. So I think it's easy to put together an argument to say that the court has said not just that the upper limits are harmonised, but also that the lower limits are harmonised. So that is, if a member state selects from the list, then you select it all. You're not allowed to carve out a sub-part of that exception from within the terms of Article 5, 2 or 3. Now, that, I think, was no one's intention at the point this process began, but I certainly think it's possible to read provisions of DR and TV2, and also most recently the Deckman case, to suggest that, to some extent, if you take this, you take it as it stands. Furthermore, what we've seen is the court turning those broad categoric prototypes into workable legal tools. And perhaps I think the best example of this is the recent Deckman case concerning parody, where the court looked at the exception for caricature, parody, and pastiche in Article 5.3. As it stands on its own, it's not a useful law, because it would appear to allow exceptions for any sort of parody, regardless of commerce, whether it's target or weapon parody. But what the court does is the court says, well, we give you a definition of parody which is broad, but at the same time, member states are obliged to ensure that it's applied in accordance with a fair balance. So you get two elements. When they're brought together, a broad definition of parody plus the fair balance, you get a provision that can be applied effectively. And you also get a provision that can be applied by member states, but where the meaning is supervised by the Court of Justice, because in the end, because you need to have a fair balance between charter rights, then it's the court that decides what is fair in that respect. So it has drawn something that is a loose, permissive provision into a functioning system of law, for better or for worse. We also see, and this isn't just in copyright, this isn't surprising, we're dealing with generalist judges here, the references to the Charter are very much more widespread in the court's jurisprudence than they were only a few years ago. There's rarely a copyright case now which doesn't make some reference to fundamental rights. What the references to fundamental rights allow the court to do is to trace law in areas where it didn't previously exist effectively. It imposes obligations in the spaces which the directive left. But more than that, we notice that if users in some instances have to be able to use a work because fundamental rights demand it, then effectively in those circumstances, the permission, the exception, becomes a right. And that may well only be in certain limited circumstances. That might only apply to quotation, to parody, to news reporting exceptions. It won't necessarily apply to, maybe it would, the right to play music in a religious ceremony or on a public holiday. But in those areas, the intervention of the Charter effectively means that limitations and exceptions are rights, effectively. Also, arguably, if this system is now framed on the Charter as a kind of, sure which is at the top and which is at the bottom, but if the Charter effectively provides a superior framework within which copyright law sits, then, arguably to some extent, we already have an opening clause derived from the Charter in a very limited way. So that if, for example, let's say it was necessary for some reason or other to quote from a work which had not previously been published, that wouldn't be acceptable under the list in Article 5, but I can envisage situations in which that might be necessary in the freedom of expression interests of the speaker. And of course, in those circumstances, the superiority of the Charter to the secondary rules of the directive mean that the list must be opened up somehow or other. I suspect by the court relying directly on the Charter over the head of the framework. So all this is already there. It may not be, absolutely trumpeted by the court, but the seeds of these developments are there. And I didn't mention, of course, the fact that there are seeds in some of the court's judgments. If you see the second entry on the slide, in particular in the VG Voort decision, there's a suggestion to some extent that exceptions and limitations are rights anyway. And contractual provisions only have a limited capacity to control those rights. So what we see here, and I think this is, you may not agree with everything I've said, but these steps are absolutely tangible in the jurisprudence of the Court of Justice. Now, that sounds like a good thing, doesn't it? I mean, effectively, there was a comment from the colleague from Austria who said, this is great because we can't do this politically, but the court can do it. And I think, actually, there's a huge amount of truth in that. That is effectively what is happening under our eyes, okay? Now, if you're a pragmatist, you'd think, well, that's okay, it's working, that's good. We see massive progress. But actually, if you're more of a purist than that, or indeed if you respect the rule of law, concepts of legality, then there are obvious problems with that, aren't there, really? And I think there are problems with these solutions, as it were. So all too often, we see the court stretching a long way in order to harmonise. So particularly this idea, if it's there in DR and in DECMIN, that if you take the exception, you take it whole. I mean, okay, you can say that, but that was never what the directive was intending to do, I think, at the beginning. I mean, that's certainly not what member states have done in relation to the instruction from the beginning. So the court is making very active, lengthy stretches. And I think the real problem for me is it's unwilling to do that. It's unwilling to say that it's doing that. And I know this might be regarded just as a question of manners, in a way. And of course, courts don't say, well, we don't know the answer, this looks a good one, so we're just going to choose it. But nevertheless, the rhetoric of these judgments seems to me to be problematic. And in particular, what seems to be problematic is the way in which the court has applied certain principles that we've already begun to hear about in order to help with the task which it finds itself confronted with. I think some of the principles that it's using, and Silke gave a long list of the principles that have been used, and I'm only going to talk briefly about a smaller number of those. I think some of them are inherently problematic. But a greater problem, it seems to me, is that they're applied inconsistently. It's a kind of, the court goes to its tool cupboard and decides, wow, this looks like a job for a chisel. I'll have a chisel today. Or, yes, I can see I want to get a... And well, actually, that makes it sound more logical than it actually is. I don't think that image quite works. So you wouldn't go to the tool cupboard and pick the wrong tool, would you? But anyway, so there seem to be particular problems with these interpretive tools that the court has been using. So it has used the notion of strict interpretation. It has sought a purposive interpretation. It's relied on fundamental rights in certain ways to get where it wants to go. And it's also used the three-step test that we've heard about immediately prior to my presentation. So I want to look briefly at how it's done, what it wants to do with each of these tools. And this draws on a piece of work I've been doing where I've been looking closely at the jurisprudence of the court and trying to kind of analyse the rhetoric within those judgments. But the examples I draw from here are particularly these four cases. The Piner case, which concerned quotation and public security. DR and TV2 Denmark, which was about ephemeral recordings of broadcasts. DECMIN, parody, of course. Technische Universität Darmstadt, which was about 5.3N, the making available to individual members of public from dedicated terminals in libraries. And in a sense, I haven't got a particular dispute with the outcome of any of these cases. Although I think the judgment's conclusion in Piner that in order for the public security exception to kick in, you need a kind of state-declared public security issue before anyone else is allowed to use it seems slightly questionable. But that apart, it's not that the wrong outcomes are arrived at, it's just that the court has had to deceive to get there. Okay, so the first, strict, why I looked in particular at those 4 decisions rather than at Article 5.1 is, of course, Article 5.1 is mandatory, whereas here you have to do more with options, and also that the provisions on fair compensation, I've left those because I'm from the United Kingdom, and they're not for me in a sense. But having read all of those judgments, I'm really pretty sure that these rhetorical techniques take place in those judgments as well. Okay, so strict and restrictive or restrictive interpretation has its origins, as you'll be aware, in the InfoPact judgment within the European jurisprudence, whereas it was said to arise from 2 things. Arise firstly from Article 5.5, but also from this idea that where you grant a right and then it's limited, the right is interpreted expansively and the limitation is interpreted restrictively. And that is a basic principle of copyright law in many of your jurisdictions. Not mine, I'd like to point out, it forms no part traditionally within the United Kingdom system. So InfoPact was revolutionary for the United Kingdom in lots of ways, but actually one of the ways was introducing this principle of narrow interpretation. But ever since FA Premier League, it's also been accompanied by this idea that exceptions should be interpreted purposively as well. Now, can you do that? Can you interpret something both narrowly and in accordance with its function? You might be able to, but what if its function is, in a sense, to reach more broadly than the words would appear to allow? There's a potential mutual incompatibility there. And this is written so clearly over the judgments of the court, because what you get the court doing is you get the court referring to the narrow interpretation principle, then referring to FA Premier League, and then just doing what it was going to do before anyway. It's a sort of, it's like a curtsy and a bow, and then on with it. I mean, effectively, I've described it here as rhetorical neutralization. They basically neutralize each other, and then the real task of interpreting the law goes on afterwards. But it's not just that. It's not just that it's inherently objectionable. It's also the fact that it's used completely, it's used in some instances, but then it's not used at all in others. So in the case of DR and TV2 and the Darmstadt Technical University, of the cases I've been looking at, there's no reference to that principle. In others, in Deckmin, it's referred to as part of the curtsy at the beginning, but then it'd be very difficult, wouldn't it, to describe Deckmin as being a case within which a narrow interpretation was reached. So we say it, but we don't do it. Okay? In terms of the purposive interpretation, I mean, in the face of it, this is much less contentious, isn't it? Every legal system has some form of purposive interpretation. Even the United Kingdom in the past, which was notorious for having a totally kind of boneheaded, literal approach to laws, always even then took some account of the purpose of that legislation as well. So, okay, the difficulty is, what is the purpose of this legislation? Okay, well, in some instances, the court has drilled in detail into the specific provision itself. So in DR, the ephemeral copies exception, in Darmstadt, the dedicated library terminals provisions, has gone to the relevant recital and have said, well, okay, the purpose of this specific provision is, let's say in DR, to extend the exception beyond the broadcaster themselves, to use that as a steer. But in other instances, what the court does is the court reaches straight to the top. Instead of going for the little scalpel to conduct its surgery, it just reaches for an enormous club and bangs the patient on the head with this club, because what it does is it looks for some overarching principle behind the scheme as a whole. So it will say, and our conclusion is supported by reference to the principal purpose of the directive, which is a high level of protection for authors. In some instances, it's kind of even odder than that. So in Deckmin, the parody case, the court refers to a guiding, overarching principle as being available in Recital 3 of the directive. What Recital 3 of the directive says is that proposed harmonisation will help to implement the 4 freedoms of the internal market and relates to compliance with the fundamental principles of law and especially of property, including intellectual property and freedom of expression and the public interest. What sort of a steer are you going to get from such broadly worded purposes? Admittedly, it focuses then in on freedom of expression as being relevant to parody, which of course is absolutely true, but nevertheless, the exercise, it seems to me, is completely pointless. What is being done there is words are being issued as cover in order to reach a particular conclusion. There's nothing wrong with the conclusion, but it's not a transparent process by any stretch of the imagination. In relation to fundamental rights, we see increasingly it's the court that drives reference to fundamental rights. So in Deckmin, the court specifically asked the parties for further information about the fundamental right arguments available in that case. So that came directly from the court. In TV2 in Denmark, DR and TV2 Denmark, the court buttressed its conclusion, which was for a relatively flexible interpretation of the exception, by saying, and this is in fact supported by the freedom to conduct a business within the Charter. So it reached for a fundamental right, in a sense, to underline its existing conclusion. The problem is there is almost never any detailed interrogation of the content of these rights. They are rhetorically very, very broad. But actually, the right to property within the Charter and within the European Convention on Human Rights is a very complicated, nuanced idea, which, it will apply in certain instances in a particular case, but it won't necessarily apply in others. But there is no apparent analysis of the rights at that level of detail. And so the notion of fair balance is employed, which of course is a proportionality inquiry at this point. But all too often, fair balance is used just as a way of saying, well, we have these set of rights here, and we have these set of rights here. This is the conclusion we would have reached on a close reading of the provision anyway. It accords with a fair balance. There's something almost religious about it, rather than actually being a useful legal tool. If these things are to be useful legal tools, it requires a much closer level of attention to what the right of freedom of expression means in European Union law. It doesn't just mean users should be allowed to use copyright works. It's a much, much more complex and nuanced thing than that. It supports political speech much more than commercial speech. It supports creative speech in certain ways as well. But if you're going to use these concepts, you have to use them not just as cover, but as useful legal tools. Finally, the three-step test. How am I doing for time? Are we? Sorry, I'm fine. Okay. Last couple of slides anyway. So, the three-step test, as you've seen, is incorporated within Article 5.5. Its original role in the Court of Justice's jurisprudence was to bolster this idea of narrow interpretation. Now, that wasn't what the three-step test was for, really. The three-step test is about controlling how broadly the exceptions can exist. It wasn't about pre-weighting the dice in particular of any particular outcome within one dispute between two parties, it seems to me. So the first thing the court did with the three-step test was to apply it again, giving rhetorical support for its conclusion, but to use it in a way for which it was never cut out. Now, in the case I've been looking at, interestingly, the court has stopped doing that. And I don't know quite why that is the case, but it has stopped doing that. It talks about the narrow interpretation principle, but it draws on this idea that exceptions should be interpreted narrowly. It doesn't use the three-step test in that way. But instead, it's used as a check on an extensive interpretation of provisions. So in Piner, for example, it said, if you read the quotation or the security exception alongside 5.5, then it's important not to interpret the exceptions too broadly. What it's doing there, of course, is it's functioning as a form of proportionality requirement. And indeed, in Technische Universität Darmstadt, this was actually said explicitly. The court says this is a form of proportionality tool in this respect. Again, you can see what's happening here, but it's not happening all the time. So, for example, in DR and TV2 Denmark, there's no mention of Article 5.5. Now, I know to some extent the court is limited by the questions that are asked by national courts, but there are lots of instances in which it has introduced Article 5 of its own motion, or in which it's drawn on fundamental rights of its own motion. What we see here is, to some extent, the use of Article 5.5 when it seems useful or convenient, and it's ignored either when it's forgotten or when it's not useful in a particular instance. So, where does this leave us? Because this whole event is supposed to be about moving forwards in a way, isn't it? Well, I think there are some reflections on these processes that I've described to you that we can draw. Firstly, and I hope this isn't right, but you might be thinking, actually, that's all ridiculous. This is just the kind of diseased outcome of a common law mind, someone who's been looking in the case law to try and find kind of lengthy, detailed reasoning which isn't supposed to be there. And if that is the case, then I'm guilty as charged, in a sense. Another possible response might be, well, okay, it might not have been the best way to get there, but pragmatically we've reached a position that is a long way further on than we were in 10 years ago, and maybe we should be thankful for that and build on some of the things that the Court of Justice has provided for us. So, in any redraft of the directive, maybe we've learned we need to provide a little bit more detail in relation to these limitations and exceptions. We can draw on things the court has already said about some of the exceptions. We might, the court is, in a sense, it's like the shock troops, in a sense, who've softened up the ground and who have even led some of us to accept that we might not be able to carve out bits of exceptions from which larger exceptions. So the legislature might now be able to move in and do this in a way that wouldn't have been possible if people hadn't already been sensitized by the court's activities. Maybe, that's a reflection we should draw on this process. But I think maybe it doesn't do to be quite so phlegmatic. Actually, I think there really are problems with what has been happening here. And I think in the legislative process, we can address some of them. Firstly, I guess there are lessons for the court. I think it should stop throwing in principles of interpretation in this way without further explanation. It would be better not to do it at all. The best thing would be to do it properly. But if you're not going to do it properly, then just don't do it. When we come to look at, and also we see, of course, in this, that there are very strong advantages of a legislative solution, because we're not going to be so surprised by the things that the court does in future. But particular things, I think, which do need to be clarified in this process, and this again is a point which Silke made at the beginning. I think it's important that we clarify where member states have discretion. You know, the fact that in a group of copyright experts like this, we still don't really know whether you are allowed to take smaller exceptions from within the larger sphere within Article 5, and we'll hear different views on that. I mean, that's kind of strange, really, and we don't know how the system is living with that degree of uncertainty. Even the Advocate General in the Deckman case said that when you look at parody, because parody is broadly worded, the member states have broad discretion in relation to interpreting that concept. That's conspicuously absent from the Court of Justice's judgment. So it's clear that uncertainty about how much discretion there is exists at the very highest level of the system, and we need to sort that out explicitly. Seems to me that if we are going to employ legislative presumptions within this new legislation, if we have it, then they need to be much more explicit than they are now. They don't just need to be kind of waffly generalities plucked from the recitals. We need to be clearer about that. We need to abandon the rule of restrictive interpretation. And I know that's very, very hard for many of you. And I'm not just saying this, I hope, because within the system that I'm most familiar with, we have no such interpretation. I'm saying it because courts are just not doing it. It's being honoured in lip surface rather than in real application. If we want to make sure that authors are well protected in future, then we need to find a different way of doing it than by saying simply every exception and limitation must be interpreted restrictively, it seems to me, because that's just too inconvenient for courts in future. We know that on the evidence of what we've seen. We need to consider the appropriate role of fundamental rights. I think in a recital to any new legislation, it should be clear that fundamental rights are not just broad principles in general, okay, but that they are drawing specific rights within the Charter and within the Convention. I'm being told I need to stop, so I'm going to stop. There's a very important point at the bottom, isn't there? But I guess we'll have a chance to talk about that when we're all talking together. Thank you.
Thank you so much for this comprehensive analysis of the work of the court. And probably we can have one question. Yeah, sorry. Sorry. Sorry, is there someone who would like to ask something? Okay. Not now. Then later on. Then let's proceed. Thank you very much. Again. So now I would like to invite Professor Alain Strowel. He's a professor at the Catholic University in Leuven and at the University Saint-Louis in Brussels, where he teaches courses in intellectual property and media law. He also gives courses in 2 advanced masters in intellectual property in Leuven and in Munich. And he's also a lawyer at the Brussels bar since 1988. And he will talk about, well, very important things, exceptions for private copying and reprography. So, the floor is yours.
Well, thank you for the invitation. By the way, where is the machine? Oh, there. Okay. It's important. So I'm delighted to be here. I would have liked to start with a discussion about what Jonathan just presented, because I think it was a very interesting summary about the case law of the Court of Justice. Its failure and as well the good aspects. I will, in a sense, focus on the same topic, but I'm not a common law lawyer, so I won't do it as well as Jonathan. And I will focus on the case law of the court concerning private copying, and as well, of course, fair compensation, because both topics go together. I will just remind you about copyright levies conundrum, the problem that we have with Article 5.2b. Just then a reminder on the principles which are already in the decision of 5 years ago. But then I will assess the more recent decisions and what they bring on top of the Padawan decision of 2010. And we had recently a decision this month in the Kooijmans case, which is in a sense interesting. But at the end of the day, my view on this case law is that what the court had to say was already said in 2010, and there is some kind of repetition because the court is not audacious enough to go further. And I think that's a good sign that someone else should do the job, probably the legislator. But at the same time, the court leaves a large discretion to the member states, and it's important to assess how large the discretion is. And I think for copyright and copyright levies, the discretion for member states given by the court is very broad. Nevertheless, I think there are two topics that the European legislator might deal with. And when you look at the case law of the court, there are maybe indications in that direction. It's the system of reimbursement for levies, and as well some issues with cross-border sales of media that are used to make private copies. I'll come back on that and discuss as well maybe the most important case on private copies and levies. It's the pending case HP, because there is a principal issue in this case that I will remind you, but we'll wait about the decision into next month, and then I will discuss the future and whether something should be done. As a reminder, Article 5.2b, that's where everything is, all the problems as well. We have a triangle. There is a definition of private copying, so some reproductions. And I'll come back on the issue of digital analog, but here the text says reproductions on any medium made by a natural person for private use and for ends that are neither directly nor indirectly commercial can be exempted. But of course there is a condition that the right holders receive fair compensation, and that's the third angle of the triangle, you legislator, take into account the application or non-application, strange to refer to the negative as well, of DRM system or technological measures of protection. Okay, so we are left with this complex triangle and how to balance the different aspects, taking into account DRMs and how to assess fair levies, depending on the way as well the exception is carved out of the copyright exclusivity. I think, in a sense, it's a dangerous triangle, and that's a reference to a film about the Bermuda Triangle, where everything disappears. And sorry for those who, because I made a presentation a few months ago on the same topic, and sometimes there might be some repetitions. For instance, a reference to this Wikipedia article on the Bermuda Triangle, where it seems copyright academics have disappeared under mysterious circumstances, and it's not clear why, but it seems that it's one of the areas where there are problems, because academics disappear in other areas of copyright law too, so nothing that peculiar with the private copying conundrums. To come back on the main decision, which in a sense said already everything, because when you look at the more recent decisions, there are a few more words and maybe some additions, but I think the blocks were already decided by the court in 2010. And strangely, I think the Padawan decision in a sense is rather audacious, but the more recent cases are not. So on the same topic, the court might change its view and become, I think, more prudent, maybe it's because the mix of judges is a little bit different. We should take that into account as well, because courts are made out of people at the end, and it should be interesting to make some check there. But okay, we are not there for discussing the way to court rules on copyright cases, but to understand, because that's the object of this part of the seminar, to understand what the law is. I think tomorrow we'll discuss more into details what the law should be. Today we are just giving some indications without entering the area of reconstruction. So there were a few questions in this Padawan case where collecting society, Spanish collecting societies, was claiming levies on blank media, and one company, Padawan, was refusing to pay the levies because they would apply indiscriminately, whether the use would be private or commercial. So not taking into account the language of Article 5.2b that we saw. So there were different questions, and the first one, which was a really important one, whether the notion of fair compensation was an autonomous or an harmonized notion of European law, and as you know, the court said yes. And there, in a sense, it was quite audacious. Then the question was whether there should be a balance, and question 3 and 4 were examined together by the court. So that was the question whether there could be an indiscriminate application of levies to professional users and private users. The last question was even not considered. By the way, that's a Padawan. Nothing to do with the case, but just a reminder of another film. So what do we have in Padawan? Something important, fair compensation is an autonomous concept, so we are pleased. And pleased because we hope that the court can say something on what fair compensation is. Now, speaking about the scope of discretion of member states, the court says that there is quite a broad power for member states because they can decide to introduce or not to introduce a private copying exception. And they are quite free to determine the form, the detailed arrangements for financing and collecting the monies, and as well the level of the fair compensation. And I think in the more recent decision, the court has stressed more often that issues about the level of fair compensation are really outside its scope for review. So I don't think that a reading, of course, of the case law of the Court of Justice would justify to move further and to try to harmonize the level of compensation. But there might be a few issues which would require some legislative developments at EU level. Reference as well to basically the fundamental freedoms and the fundamental rights. So even when discussing the interpretation of a provision 5.2b, the court refers to some principles like the freedom of goods, principles of non-discrimination, proportionality. As Jonathan said, that comes quite often, but you don't know exactly how that should apply, of course. So it's a little bit rhetoric here too, although there was some kind of balancing with reference to proportionality that the court made. So in the operative part of the decision, another important block is that the court stressed the need of fairness for the calculation of levies. And the calculation should be based on the harm caused by the private copying exception. Now, who should pay, who should be liable? Well, in principle, it's the person who are making the private copies, but the court is rather broad in accepting that person who have digital equipment or who make that equipment available to private users have to pay, because they are able to pass on the levies to the final debtors, that is the private person making the private copies. So because they are able to pass on the levies, it's fair that they are liable. And you see the wording is very broad. It's people who have, that's the term, who have the equipment. So it's not a notion of ownership. It might cover different types of relation between the equipment and the person in charge of paying the levy. There should be a link, of course, between the levied item and its use for private copying. And then the most practical aspect of the court was to stress that an indiscriminate application of the private copying levy, which would apply to all types of equipment or media sold, whether they are used by private persons or by professionals, that would go too far. So equipment which is acquired by undertakings for purposes clearly unrelated to private copying, because those are professional use, should not be levied. We'll see that the court in the more recent decisions is a little bit more, I would say, a little bit more decisive on that. So no levy in that case. That's quite clear if you have a professional use, but the question is that whether you have still an exclusive right. I think that's an open question. So the more recent cases of the Court of Justice of the EU, and you see there are quite a lot of cases, and by chance none of those cases has already been touched by the other speakers. We didn't have much time to coordinate, but at the end I think we are dealing with other decisions, and that makes it, I think, more interesting for the public today. So all those cases, including the March 5 decision in Kooijmans, I will review them briefly. The main issues that have been dealt with, well, calculation of levies, that's in Pada 1, but it comes back into the other decisions. Then you have two decisions at least, which deal with the issues whether you can or not have levies for illicit copies, and the answer is no, according to H.C. Adam and Kooijmans. Who should pay levies in the case of cross-border sale? There is some kind of discretion by member states there. I'll come back on that, but I think it's one of the issues where the Commission might consider to do something if it focuses on cross-border issues in the next round of legislation. The issue of the effective right of reimbursement is as well an important one, where the court has said something in Amazon, in Kooijmans. Again, it's not very precise, but I think it's maybe a call for further action at legislative level, if at least there is no effective reimbursement according to the criteria put forward by the court. Then there is one of the worst decisions ever, I think, of the Court of Justice, in VG word, impossible to understand for certain paragraphs. So some of those decisions are well drafted. I think that's not a very good example. I think the court did a better job in the more recent decision, although there is as well one paragraph which is really impossible to understand, at least one. So that's the issues of the chain of device, whether you can have levies on one machine in the chain of device, or whether you can spread it over the chain of device. And we'll see that there is quite, again, a lot of discretion of member states on that issue, and the notion of levies on multifunctional medium, and the issue of minimal harm. When the harm is minimal, should there be levies, is partly dealt with in Kooijmans, the more recent decision. I think on that issues, probably you know, I mean, that's not really new. So there is no need to prove actual harm to the author to raise a levy. And there is the de minimis rule when the prejudice is minimal, but I'll come back on that issue because Kooijmans says a little bit more on that. But at least we have the rationale of levies. It's a way to compensate for the harm. Of course, we knew that, so to say what the court said is not that helpful, of course. No levies for unlawful copies, that's quite clear in AC Adam. Again, I mean, the facts are more or less always the same. You have parties, usually they are importers and or manufacturers, and usually it's of media, not of machines, in most of those decisions. It's not the case in the VG Word decision. They are required to pay levies, and then you have some litigation in one of those countries. On that issue, so the court says there is no possibility to have levies for unlawful copies. And that's based on the principle of strict interpretation of Article 5.2b. So we see this approach applied by the court here. There is no possibility for the member state to extend the scope of the exceptions and to have levies beyond the scope that is defined in Article 5.2b in that case. And there would be as well internal market issues otherwise. Yeah, that's an old reference because we had already some idea that that could not work to have, for instance, some forms of levies in case of illicit peer-to-peer file sharing. That was already mentioned by one of the Advocate General. Thuiscopie opus, again, more or less the same facts, blank media sold, but they are sold online here by a German company via a Dutch website, which targets, obviously, Dutch buyers. And no levy is applied, so you have the case brought by the Collecting Society in the Netherlands, Thuiscopie, and then reference on the interpretation of different provisions, 5.2b and 5.5 as well. What is important here, I think, is that member states, according to the court, must have a levy system which ensures that the levy applies on the territory where the harm occurs. So if it's impossible to recover from the final user, here in the Netherlands, for instance, the final user being the importer of the blank media, then member states must find a solution which allows the recovery of the compensation from the seller who contributed to the importation. I think maybe this decision opens the way for discussion whether something should be done in order to implement this decision, because cross-border difficulties remain, and I think they might still consider as some form of impediment for the functioning of the internal market. Because when you look at all the steps that must be followed by the manufacturer, it's quite burdensome. And I think it should be solved, especially the problem with the reimbursement system, which is quite burdensome and probably for that reason not really into operation in many countries when you have sale over the border. So I think we have a problem there. The reimbursement system, according to the court in the Amazon decision, must be effective. So it shouldn't be excessively difficult to repay the levy paid under the reimbursement system. And it's for the national authorities to verify if there are practical difficulties to distinguish between the buyers, some of them being exempted to pay the levy, others not. And it's for the national authorities as well to verify the scope, effectiveness, availability, publicization, and simplicity of use of the reimbursement system. I think that's the most important part of the Amazon decision, and as well, of course, the reasoning of the court concerning the possibility to have an indirect compensation of the right holders, for instance, through social or cultural fund. that seems allowed by the court. So the court clears some practice and some rules in certain member states on that issue. Paragraph 52 is interesting concerning the objective that the courts stress by the system. Concerning the different types of private copying, I think that there was already some reference to the fact that in the first directives it was only digital issues that were, of course, addressed in the software and in the database directive, and there is no private copying exception for those works, as you know. Then we have two exceptions which might be considered as covered by the notion of private copying in the InfoSoc directive. It's Article 5.2b already discussed, which obviously concerns analog and digital worlds because it's reproductions on any medium. But we have still an analog art exception, which is sometimes treated by certain member states under the private copying exception, and that's the reprography exception, where you have reproduction on paper. When you compare the two exceptions, you see the difference not only about the medium on which the reproduction has to be made. In the case of reprography, it's paper or similar medium. You don't have the same restriction concerning natural person, so professional copies might be covered by the reprography exception. You have a reference to photographic technique, but that doesn't seem to be very selective as a criterion, because you have as well the possibility to use other processes which have similar effects, and that's quite broad, obviously. And there is no reference to DRM, otherwise there should be as well a fair compensation. There was one case dealing with the reprography exception, and that's why I just introduced it to 5.2a. It's a VG Voort case, where here we have manufacturers of PCs and printers. So it's not only media. Here we have the machines, the equipment which is involved, and that's a German case. So basically the court leaves, again, a lot of room for member states. Because there is a possibility to apply a levy on a chain of device. And it's even possible to have the levy only on one device in a chain of device, which leads to a copy covered by Article 5.2a, sorry. So, for instance, if you have a chain of device and a PC and a printer, out of the chain of device, you have a copy on paper, and that's covered by 5.2a. But there is a possibility to have levies only on the printer or only on the PC to court, or on both, and then to spread it over to different machines. So again, freedom for the member states. Then there is the issue whether there should be levies in the case you have a permission, an authorization. Well, that issue has no bearing on the issue of fair compensation. So the notion of authorization, it's confirmed in the last decision. Whether the copies have been authorized or not is not relevant for the court. It seems a little bit contradictory when you read some of the paragraphs of the third decision, but whatever. There is no complete, maybe, consistency there in the case law. And there you have some kind of development which are really not understandable for, I think, copyright lawyers, for anybody, about the distinction between an exception and a limitation. At least I would be happy to have your reading on that. Again, on the issue of DRMs, they don't affect the issue of levies. If they are DRMs and they are not applied, that doesn't mean that no levy is due. But of course, the level of compensation might be linked to whether DRMs are available and whether they are used. So the court leaves again a lot of room for member states. In the last decision, and I will finish by that one, well, with a reference to the Rob case, still, there were different issues. For instance, the notion, when is there a minimal prejudice which does not require some form of fair compensation? There were then other issues which were already dealt with in previous decisions, when there is, for instance, authorization, when there are some form of licenses, or whether there should be some consideration for the application of DRMs. One of the most interesting issue is the issue about discrimination between different technologies, in a sense. That was an issue already addressed by Maria this afternoon. So because here there was a possibility in Denmark apparently to have a levy on memory cards in mobile phone, whose primary function is not to make private copies, but at the same time there was no remuneration for the internal memory of other devices. So is that discriminatory? Technologies are a little bit different. And the situation concerning the levies was very different. So what did the court say? Well, multifunctional medium are deemed to be used for copying. So it's not because you have different functions that there shouldn't be any levy. And even if the main function is not to make copies, you can have levies. Because those multifunctional media are deemed to be used for copying, even if it's only one and maybe not the most important function. But of course, that should be taken into account to determine the amount, what the court refers to as the level of compensation in other decisions. I don't know why they use here amount, while in other decisions they refer to level. I think there is some inconsistency in the language sometimes, which makes things more complicated to follow. So, and that should be by reference to the relative importance of the medium's capacity to reproduce. At least the reference to capacity of a medium seems to be a good reference to assess the level of the amount of levies. And of course, if there is a very rare use of the medium to make private copies, then we might fall under the de minimis rule. So no, I should stop. Okay. Well, okay. I think you will have access to the presentation, so I don't have to go into all those issues here. There were very many questions and sometimes very detailed. One additional point, so that you see that the court adds something, usually, but not that much, into more recent decision, whether the device is owned by the person making the copies or not is not relevant for the court. So the device that is used for making copies of protected work by a natural person, this device could belong to a third party. But at least there are three elements for the court: a protected work, it's a conditional natural person, and then a medium, but the property of that medium is not relevant. Strangely here, the court says that there shouldn't be any reading of Article 5.2b at the light of Article 5.5, contrary to what the Commission had claimed. So here the court doesn't want to use the more flexible criteria of the three-step test in order to assess other exceptions. There is one pending case, and it's a Rob case, which raises, I think, one important issue. First of all, it's a case involving a dual system that we have in Belgium, because that's a Belgian case, but it's the same system in Germany and in other countries, where you have a lump sum payment by manufacturers based on some aspects of the machine, capacity or speed in Belgium, so that's a problem. Reference to the speed for the machine to make the copies. But we have a dual systems in the sense that on top of that lump sum payment on the machine, determined by a criterion, there is a proportionate remuneration paid by end users based on the number of copies that are made, for instance, in a library or in a company or in an administration. The other important issue is whether you can have a system which allocates half of the fair compensation to the publishers, although the publishers have no right on the basis of Article 2 of the InfoSoc Directive, because it's only authors which have a reproduction right. So we'll see what the court says on that. What about the future? I think there should be something, and the court has indicated in a sense that more should be done, because there are risks for the functioning of the internal market. So that might be a sign. It's interesting to see how the court behaves when it interprets the constraints imposed by the InfoSoc Directive. And there you have the two main recitals that are used in the recent cases, at least. The recital which refers to the need for a high level of protection, and then the next one which refers to the fact that the right owner should receive an appropriate reward. And that has been interpreted as not requiring a maximum remuneration. So when you look at those two recitals, you might only read the first one and think that the protection should be very high. But the court doesn't, the recital doesn't say the highest level. And in the next recital, there is a reference to the appropriate and not the maximum recompense or reward. So I think based on the case law, there might be some reason to try to move forward on some issues. In the case you have cross-border sale, and in particular the reimbursement system, because that's an issue which involves as well some cross-border aspect. But I mean, I don't want to be involved with that legislation if someone thinks that it should be dealt with, because that's really a black box. Otherwise, I think there will be a lot of difficulties to move forward, because it's difficult to reconcile the different positions which are summarized there. And I think because of the very opposing interest in this field, we should not expect much. And I think the court has said a lot of discretion should be left to the member states on that aspect of copyright law. That was it. Thank you.
Thank you so much, Professor, for this comprehensive overview. As we are out of time, would you mind that we leave the question to you after the coffee break? Sure. Thank you so much. So let's go to the coffee break and let's meet after 15 minutes, 4:15.